Hello, everyone, and thanks for joining us. You're listening to a podcast from Constantine Law. I'm Eliza and Nash, a partner at Constantine, and I'm joined by my colleague, Ellie Rogers, a senior associate. The topic we're going to be discussing today is the new duty to prevent sexual harassment. Now, this duty applies to all employers, and it comes into force imminently on the 26th of October, so it really should be top of the to-do list. Today, we're going to be looking at the following areas. What does preventing sexual harassment actually mean in practice? Guidance from the Equality and Human Rights Commission on how employers comply with this duty, the risks for businesses of not complying, and what employers can do now. But first of all, Ellie, could you just tell us a little bit about where the legislation has come from and why we need it?
Absolutely. Thank you, Eliza. So cast your mind back to 2018. You'll remember the Me Too movement. The government entered into a period of consultation about workplace culture. It found that sexual harassment was widespread and also that it often goes unreported. The consultation showed that specific groups were disproportionately affected or susceptible to workplace sexual harassment. So, for example, young women and also those who are in more sort of precarious roles. So, for example, in the services sector. Now, the Labour government estimates that now 1 in 2 women in the workplace have been sexually harassed, which is quite a staggering figure. I've worked over my career with lots of people who have been sexually harassed in the workplace, and the impact on the individual can be lifelong, affecting their mental and physical health, but also their career progression. And in the worst cases, sometimes it means they can't continue in their role.
Absolutely. And I've had similar experiences with claimants. And of course, it's not just isolated to the impact on the individual. The negative impact on the business can be huge. A decrease in morale amongst staff, an increase in absenteeism, high turnover rates, and if it's made public, then significant reputational issues. I think we only need to look at Harrods to see what happened there.
Yes, there's certainly quite a lot of fallout from that case. So there's clearly a need for new legislation. And finally, in October 2023, the new Act was introduced. This comes into force, as Eliza said earlier, on the 26th of October. And ahead of this, the Equality and Human Rights Commission issued their technical guidance. The final form of the guidance was introduced last month in September, together with a really helpful 8-step guide.
So the duty is to take reasonable steps to prevent sexual harassment. But what does this actually look like? Well, it's clear from the Commission guidance and their 8-step guide for employers accompanying this that no single step will of itself be enough to comply with the duty. So, for example, having comprehensive and up-to-date policies and procedures in place is a good start, but a lot more is going to be needed. Direct engagement with your workforce is likely to be key to this process and working out what needs to be done. One employer, a client of mine, recently set up a staff group specifically for the purposes of looking at reducing racist behaviour because they'd had quite a few racist incidents involving customers. So things like that, I think, are going to become more prevalent or need to happen more in the workplace. There's also a great deal of emphasis in the Commission guidance on the need for employers to conduct risk assessments in order to identify risks which are specific to their business and then put in place measures to mitigate against these risks. So examples of this might include carrying out anonymous staff surveys, and exit interviews are also a good way of gathering information, although it can be a bit late in some cases by that stage. This sharp focus in the guidance on risk assessments is something we're used to seeing in the health and safety context. We're not so used to seeing outside of that. And I think it's relatively new and I think has come across from the approach taken in Australia, where they've got a similar law in place that's been in place for a little over a year now. And that's right, isn't it, Ellie?
Yeah, absolutely. I mean, frankly, the Australians are really leading the curve here. They introduced a similar duty back in 2022, and then in August 23, the Australian Human Rights Commission introduced their own guidance. And there are lots of parallels between their guidance and ours. They stress the need to risk assess and also the importance of training.
Yes, and that's another really key area that comes across here is the need for training and the need for targeted training tailored to your business, and also which is going to vary depending on who you're delivering it to. So training for managers, which we'll need to look at dealing with complaints, is likely to be quite different from training for staff generally, which is probably going to be more focused on awareness of the duty. There also needs to be regular refresher training in place, and we'd actually suggest every 12 months is likely to be needed. Now, under the existing law, it's currently a defence to a harassment claim for an employer to show that it took all reasonable steps to prevent that harassment. This new preventative duty very closely resembles this defence, and we think it's likely that tribunals are going to be taking a similar approach when it comes to enforcing this duty. A couple of years ago, I acted for the employer in the most recently reported case on the reasonable steps defence, and the decision of the tribunal in that case just shows just how high the threshold is for employers to succeed in it. So in this case, the employer was a casino, and a racist request had been made by one of their patrons. They didn't want to be served by a black woman, and the member of staff on duty accommodated that request. The employer ran the reasonable steps defence, and in its decision, the tribunal found that they had appropriate policies and procedures in place. They conducted an effective complaints procedure, and they'd also carried out training within the previous year. Where they fell down was that their training was not specifically targeted enough towards the behaviour in question. They didn't have enough specific training on inappropriate and discriminatory behaviour by customers. So I think that sort of shows how high it might be, or just how much is likely to have to be done by an employer to meet the threshold and comply with this new duty. The third area for employers to focus on is having an effective channel for complaints. Now, we hear a lot these days about having a speak-up culture, but what does this mean? Well, I think essentially employers are going to need to make it easy for employees to raise complaints. Don't make them jump through lots of hoops or fill in a certain specific form, and take those complaints very seriously when they're raised. Ellie, what do you think about that?
Yeah, absolutely. So we've seen in quite a few companies, particularly the larger ones, that they will have a named point of contact so that it's really easy who the complainant should go to, and that the contact is specifically trained so they can support the individual, but also make sure that the complaint is progressed properly. So in summary, I think we're right in saying that there are a number of things that need to be done. So developing robust anti-harassment policy, making sure everyone's aware of it, ensuring there is regular risk assessments, targeted training, ensuring that everybody understands what is expected of them, and also how to make complaints and support there. And I suppose it's important to note that the duty is proactive, but it's also ongoing. So you can tick all the boxes now, but you will have to keep on assessing, keep on taking reasonable steps. We will go into this in more detail at our webinar. We'll give you more details at the end of the podcast, but we really hope you'll join us so that we can help you go through those proper steps.
Absolutely. Absolutely. So what are the risks? What are the legal risks for employers failing to comply with this duty? Well, the real or the main risk is that if an employee brings a harassment claim and are successful in that, then any compensation that they're awarded can be increased by up to 25% if the employer has not complied with this new preventative duty. Now, on the face of it, that might not sound like a huge amount, but it can be. So bearing in mind that compensation for harassment claims is uncapped. If you had a claim, for example, which involved a loss of a bonus entitlement, compensation could stretch to hundreds of thousands of pounds or beyond. 25% in that scenario is a fairly significant sum.
Indeed, I think that sounds like a pretty big bill if you get it wrong. But aside from that, the Commission also has the power to take enforcement action against employers if there's evidence of them not complying with the duty. So there doesn't have to be an act or an incident or complaint of sexual harassment for the Commission to get involved. We've heard through the press that the Commission will robustly defend the duty and enforce it. We'll have to see what happens in this space, but clearly, if there is potential for a significant reputational risk to companies if they get it wrong. There's also another thing that we haven't mentioned, and that's third-party harassment. So this is in the context of preventing sexual harassment from clients and customers, so people outside the organisation. This isn't included in the Act, but the guidance goes into quite a lot of detail about it. So what do you think the implications are for employers, Eliza?
It's a really good question. And I think, employers will know that it's not always possible to control the behaviour of their staff. It's likely to be harder still to control the behaviour of third parties. Signage is one way, particularly in retail and hospitality, but, businesses may not want the first thing their customers to see being a great big sign saying, "Do not sexually harass our staff." In terms of using contractors and freelancers, it may be a question of inserting clauses in commercial contracts requiring compliance with the duty. We don't know. What we do know is that the emphasis is there, and the need to protect is there, and any risk assessment will need to factor in the risk posed by third parties, be they contractors, be they customers or service users. Okay, I think, Ellie, unfortunately, that's probably all we have time for today. But as you can probably gather, this is a really important change to the law and something that businesses need to be across pretty quickly. We'll be talking quite a bit more about the implications for your businesses and also the practical measures that you can take to prepare in our webinar on the 15th of October. So we'd love you to join us then. Please do. You can find the registration link in the podcast notes or otherwise email us and we can send you the details. Thank you very much for joining us today.
Thank you.